You're welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile, we put Ghana first and get my guests ready to begin with this morning's discussion. Alfred Tia Yeboah is former Deputy Attorney General, Minister of Justice. Inusa Fuseni is former MP, Tamale Central, and former Minister for Lands and Natural Resources. Professor Kojo Appiah is Professor of International Law and Human Rights, School of Law, University of Ghana. Dr. Kojo Pumpuni Asante is Director, Public Engagement and Partnerships, Ghana Center for Democratic Development. And here, right here in the studio, first to be here, Kofi Bento, lawyer and Senior Vice President, Imani Africa. You're going to help us to canvass the issues that we have tabled for discussion for you this morning. And as you can see, I didn't do a Samson steak, but I've got a minute to make this, comment, which is very important to me because the Constitution 1992 is very clear in the human rights provisions in Chapter 5. Now, Article 14 is very clear that when a person is arrested, restricted, or detained for whatever purpose by law enforcement, that person ought to be informed in a language that they understand, and their right to a lawyer of their choice. The Constitution insists that they ought to be presumed innocent until they themselves have, as it were, admitted to their guilt of an offense they have been charged with, or that a court of competent jurisdiction has so pronounced them guilty after evaluating evidence against them. As far back as 1966, the hallowed principle that has come to be known as the Miranda rights in Miranda and Arizona is now entrenched on all international, human rights provisions, and every country that is a democracy, even countries that are not democracies, deal with the innocence presumption of innocence, as well as making sure that a person who is arrested is read their Miranda rights. They are told that they are not supposed to say anything at the point of arrest, because anything they say could be used against them. The law says they are entitled not to self-incriminate themselves. That's why there's a need for a lawyer to assist them. That's why when they don't have a lawyer, the state provides them lawyers. That's why when someone who is accused of murder, even when they are put before a court and they plead that they are guilty, the law says the judge will hold that they are not guilty at that time. And if they don't have a lawyer, at all costs, the state must get them a lawyer to defend them for the case to be heard on its merits. My friends in the police, in the national security, in law enforcement, let's not bastardize this democracy. What is his name? Is it Abutrika or Frederick? Yes, Abutrika or Frederick Kumi. What was that for? You arrest a person and you are, extracting confession statements, you record it and you put it out in the public. No law enforcement will do that. Those officers who were superintending that, you don't deserve to wear the coat of arms. You don't deserve to be called a law enforcement officer. It's completely wrong. You turn the law on its head. You never do that. It is the reason, even the law, if you want confession statements, there are parameters under law over which confession statements can be taken. Otherwise, it will be invalidated. You can do a whole trial from beginning to the end, and it will be botched because you guys are doing this wrong thing. I'm aware that a lawyer tells me he got bail for 10 suspects over a matter. And at the police headquarters, at the Special Investigations, unit, a court grants them bail. For almost 3 weeks, the people were still being kept under custody because they wanted to use those people to get one other person who they are not getting. Really? In a democracy? You guys have to be very careful. If you are law enforcement agencies, you must do what the law requires of you. You don't do what you have done. It's completely wrong, and we must deprecate it. All right. So, my guests are here. Let's begin from Rebel. Would you want to choose of the three topics? Where should we begin? Should we begin from the Supreme Court halting Kpandai rerun, Oforiatta's fight against extradition, or the mediation verdict?
I'm fine with all of them, but I have Kpandai as the first.
Thank you. It's what is advertised.
Yeah.
Right.
So, see, as usual, I have my own views about Kpandai. They are not simple. They are not comfortable, but these are my views. And I come to these views very slowly, observing for a long time, what is going on, and then I conclude. And when I conclude like that, I tell myself that I'm wrong, and then see how the facts will play out. And many times I've said things here, and they just turn out to be true. This is the problem with Kpandai. You have two factions in a space, and each of them has a case. You listen to the Kusasi side, they are the Aborigines, they have a case. You listen to the Mamprosi side, they have a case. Now, seeing that each of them has a case, none of them is prepared to yield. Peace requires compromise.
That's not Kpandai.
Sorry.
That's Bok.
I'm talking about sorry, I'm mixing those. Sorry, so let me not use the names.
Okay.
We are speaking about Kpandai.
Right.
Kpandai is the election rerun.
That's right.
Okay, sorry. I was speaking about the Mamprosi thing.
Right.
But, okay, so incidentally I was in court. And when Kpandai came up, we said some very simple things. What we said is, one, until the justices of the courts make a final pronouncement, nothing is final. And I went as far as saying, and I put it on Facebook, that an election is not won at the polling station. Speaking law, because the EC officers are officers of law. If they don't do their work according to law, it is all null and void. Led by Akoto Ampao, I went to court to have the processes set out, how you do this and that, patient. If you don't use that process, which is a legal process, the whole thing is off. I gave the analogy that, look, if you win an election by 10,000 votes, that is what happens at the polling station. If in a court it is shown that 5,000 of those votes were invalid, you did not win, the court will determine that your number is 5,000. So it is a court that finally will adjudicate whether you have won or not, unless the other party doesn't take it up. To that extent, the principle has been clear. That
the principle of election petitions is that, as you said, if the court impugns 5,000 of the votes, and those 5,000, if they were dashed to your opponent, will not change the results. They leave the sanctity of the vote.
Correct.
Don't touch it.
So that's the math. But the court decides what happens at the polling station is valid or not. So my point is, getting 10,000 votes at the polling station does not mean you have 10,000 votes. The court will decide what votes you have. We need, look, I started saying this from the first presidential petition, that as a country, we need to put in our minds that the justices are the supervisors of the realm. And it is what they say that is final. And I have said, and I repeat, this idea that you win elections at the polling station, much as there is some truth to it, it generates violence. What we must tell people is this: in a proper, lawful society, it should be possible for a person to go and vote and go home. In a proper lawful society, it should be possible for persons involved in an election not to have observers. In a proper lawful society, it should be possible for the citizens to trust the Electoral Commission so much that they don't mount whole armies, people don't snatch ballot boxes, and don't engage in all kinds of lawlessness to so-called protect their vote. If we did just that, then you will see a situation where the justices don't come in. But as long as we keep saying you win at the police station or you lose at the police station, etc., people do all kinds of things over there, and then the thing ends up in court. And please, when it ends in court, this is where Inusa and his people come in. When a matter is sub judice, it is not determined, do not take a step to overreach the court. Indeed, that is what the justices said. So, having had this problem...
When it's a matter sub judice, you are talking about a judgment of the High Court in Tamale that has invalidated the election and made a clear order that let's have a rerun of the elections in 30 days.
Correct.
And that is what the processes have kicked in to, as it were, execute and implement. So,
to the extent that that judgment is not challenged, it is the law. A bad ruling, what we lawyers call per incuriam, even if it is not in line with the law, as long as it is not challenged, it is the law, and you have to obey it. But immediately it is challenged, everybody must understand, it can change. To the extent that it can change, nobody should proceed on what is not fixed and make permanent or fixed decisions. All right? So what we are saying is, when the judgment of the High Court came out, it was law. When it became a judgment subject to a challenge, everybody, including Parliament, should have taken notice that this can change. And therefore, you have to organize yourself with that in mind. As far as I'm concerned, the EC also should be mindful that it is a creature of law, and between Parliament and the Supreme Court, the EC has to listen to the Supreme Court. In the first place, they are the cause of this problem.
The Supreme Court has not spoken until they gave the suspension.
When I say listen to them, I mean when
the clerk of Parliament operated on the basis of the Constitution and proceeded to issue the notice to the Electoral Commission declaring a vacancy. The law says once that notice has been issued, the processes, the EC must within 30 days ensure that the elections are done.
My point.
Are you saying the EC could have done otherwise?
I'm saying that the person who declared the vacancy made a mistake. Which is why I'm saying Parliament should also listen to the Supreme Court or abide by the laws, appreciating that it is the justices that finally decide.
Tell us why the person made a mistake.
Because it says when a seat becomes vacant, and my humble submission is that as long as that challenge is extant, as long as that challenge is going on, it has not been declared ultimately, finally vacant yet. Because that vacancy will have to be declared by the Supreme Court or the court before which it has been put. So, to the extent that there was a challenge, I think the proper thing should have been to hold our hands. And somebody will say, well, what if it never gets called and it doesn't get adjudicated in time? That is why we have to have our elections court.
As a lawyer, you say that what you would tell your clients when they have been victorious in a court and there is no impediment in their way, regardless of an pendency of an appeal, which does not operate as a stay, to stop them from realizing the fruits of their victory in a judgment. They should
I'm saying the contrary. When there is an appeal, immediately an appeal is filed. Even that is not a stay.
Correct.
Okay, but we are talking about state institutions. We are talking about EC, Parliament and co, which have to respect each other and also appreciate that, look, what happened can happen. All of us were saying, don't do this because the Supreme Court can stop this thing, and they ended up stopping. So the point I'm making is, when you have an appeal, look, in private matters, conduct can be different. And can be, we are defending people or we are, pushing people's cases. We'll move forward. But in these constitutional matters, state issues, the proceedings of government and co, I think the attitude must be different. My point, and I repeat, I said it before the Supreme Court made a ruling, and I'm saying it now, is that when the matter went on appeal, that seat should not have been declared vacant. because an appeal can succeed.
You have been told about the mischief rule. So the state must take a step, but I want to scuttle that step. So I go to the court and file a process. There's no order, there's no judgment from the court. And you say the state must stop and wait until a decision has been
There are rules about the performance of constitutional duties and state duties. So where it hasn't risen to that fact, yes, the mischief rule, we all know it. But we have to make a distinction between the mischief rule and people's rights, which is why we repeat, we need to have our elections, petitions, courts. So if the person is within his rights, he has filed a proper appeal. Of course, he should go ahead and do the stay of execution or whatever it is.
Yes, they filed the appeal, filed for a stay of execution, and proceeded with the certiorari application in the Supreme Court.
They should go ahead and do all those things. But I have been in the Supreme Court, where we have filed a case, which has been heard, and dates have been set for ruling. And before the ruling came, the government proceeds to do exactly what the case is against. We file an injunction because the state calculated and breached what was there. We go there, and the Supreme Court justices are saying we should withdraw the injunction because it has been done. The state calculates to overreach the court and disrespect it. So we are saying people do these things. But when it comes to state issues, look, we have a situation where EC proceeds to go and do an election, spends money, starts mobilizing, then the Supreme Court comes and says, stop. It is our money that is being wasted. That could have been foreseen. If they had just responded or respected some of the principles, this is not my mind, this is the law, we would have avoided all of this. What I'm saying is, look, mischief rule, all those things, let's clear them. But the right of a person to appeal...
You are referring to the Ayimensa, it's a gentleman represented by Afenyo Marking. Because of that single individual, the Supreme Court stopped the whole District Assembly elections, and all the expenses that have been made went to waste.
And that is willful, loss. Somebody decides, I'm going to go ahead. The Supreme Court just makes a ruling and all that money is lost. And I'm like, couldn't you have foreseen this? If you didn't foresee it, we saw it, we said it. So look, going forward, we should stop these things. It's happening too much.
Professor Piejetia, the Clerk of Parliament did, as we understand, simply respect his constitutional obligation. Article 112, Clause 5 says, whenever a vacancy occurs in Parliament, the Clerk to Parliament shall notify the Electoral Commission in writing within 7 days after the vacancy occurred. And a by-election shall be held within 30 days after the vacancy occurred. The Clerk wrote to the Electoral Commission saying a vacancy has occurred by reason of the judgments of the High Court in Tamale, invalidating the elections in Kpandai and ordering a rerun in 30 days. After he did that, and even the petitioner's lawyers felt the Electoral Commission was delaying, they had filed processes in court to hold the Electoral Commission for contempt. Did the Electoral Commission do anything wrong? And what do you say about the Supreme Court's intervention in suspending the December 30 rerun?
Thanks for having me on, Samson. I totally agree with the position.
Hello, Prof.
Hello. Can you hear me? Hello?
Prof, unmute your mic.
Unmute?
We can hear you. Go ahead.
Okay, thank you. So I'm saying that I completely agree with Mr. Benson's position. And so for that matter, my point is that, and I also agree with the position that it is not the EC that should be faulted here. For the EC, so long as the Clerk of Parliament has issued that letter to the office of the EC, I think that they are compelled to follow the direction that has been issued from Parliament. And so at the end of the day, the fault should not be laid at the doorsteps of the EC. The fault should rather come from Parliament. The Speaker made a ruling referring to the mandatory 7 week...
7 days.
The 7 days stay, which was respected by Parliament. But the matter has been, the appeal has been taken to the Court of Appeal, and then the NPP has proceeded to go to the Supreme Court for that decision by the High Court to be quashed. I think that here the matter should have stayed, and the Member of Parliament, Matthew Nimdam, should have been allowed to remain in his seat until one of the decisions, whether the Supreme Court one or the Court of Appeal one, is determined, so as to bring finality to the matter before the EC should proceed. I think that is the proper way that the process should have gone.
So what do you make of the Supreme Court's intervention by the suspension?
It is a proper thing to do. I think that the Supreme Court made the right decision. And so you can see how the NDC candidate was trying to frustrate the process by, I think, in my opinion, evading service. And so the court making that decision that the NDC member should be served, and then going ahead to say that a date should be set for the matter to be determined before the EC can go ahead is right, so that when the matter is determined on after January 13, then we can be clear that this person should remain in Parliament, which is likely to maybe completely abolish the process for the election process at all. Because if at the end of the day the decision by the Supreme Court quashes that of the High Court, then Matthew Nimdam will continue as the Member of Parliament for Kpandai. So it will bring finality to the matter. And so it calls for making sure that the process are followed, there's a little bit of patience applied, and then the matter can be resolved in a peaceful manner.
Right. Dr. Kojo Pomponia, I don't know where you stand with this. He said both of them are saying things should have been slowed, Parliament should have, been restrained. But the very day the judgment was delivered, even though by law, statutorily, 7 days ought to have been allowed to elapse before you can attack the individual. The very day the judgment was delivered, was it that same day or the next day in Parliament, he was being chased out. And guess who were the people championing he being not being qualified to come into the House? Lawyers.
Those defending Kwesi.
Well, thank you very much, and a very good morning to viewers and listeners. First of all, for me, the Kpandai case is very important for many, many reasons. And it's not just the Kpandai case, but almost all the cases that at the end of 2024 went trying to determine the collation of results and all of that. I think we have to find time and bring all those cases together, because we have a huge governance challenge. And myself, you have been involved in some of the work we did from 2023 to 2024, trying to shorten the time for adjudicating parliamentary petitions. But we have not fixed these problems around the results matrix, and it's impacting our governance processes. So in the last parliament, because you had almost a hung parliament, you had very serious disruptions. Who was a speaker, who was majority, who was minority, and then you get all these vacation of seats problems that were coming up. So it goes back to what the processes are, and how do we ensure that those processes don't negatively impact on the way we govern our space. At the moment, there are just too many gaps. Some of that has to be filled by legislation, either through the Electoral Commission's own CI processes or the rules of court or that, but the gaps remain. So for me, the common sense is that once you are adjudicating a process and you know that appeals processes or it hasn't run its course, then by default, you have to create room for those processes to be finished. Because what it does is that it incentivizes, very bad political behavior. And then if people want to sort of take advantage of the process. They can sort of engineer processes around that creates a lot of confusion. So for me, I think there's a lot to be addressed in terms of all the gaps around that. But there are two other fundamental issues that I want to put on the table. One is the management of elections itself. From the case itself, there is a sense that the Electoral Commission's officials and their conduct at elections are something that really we have to pay attention. And how does the Electoral Commission then take the step forward in holding those people accountable? So for me, for instance, after this process, the Electoral Commission should be instituting some sort of an inquiry into what has happened, so that those, whether they are temporary officers or whatever, are held accountable. Because what we did in 2012, putting in place a biometric system, was for a very, very specific purpose.
In this case, it was not the Electoral Commission officers who were to blame.
I mean, no.
The blame was heaped on party tax that were organized to disrupt the process.
No, if you look at the what was presented as the irregularities, particularly the completion of the pink sheets.
Yes, that was also an issue. Correct.
Exactly.
Yeah.
And the consistent inconsistencies, right, of the totals. It's a huge problem, because the whole idea of the biometric verification is that you match verification with the number of ballots in the ballot box. So if you are recording, discrepancies there consistently, even if it's 40 polling stations out of 100 or something, that is significant. And that shouldn't be happening at all. There's no way
of the EC.
There's no way that should be happening at all. So it is not enough that it is about going to organize another election. We have to come to the bottom of it. Who exactly was recording these things? How is it that they got it wrong?
Part of the EC's defense was that don't depend on arithmetic errors to want to seek to overturn an election.
No, but that is actually problematic. And the third issue I'll come to. But that is actually very problematic. The EC, for example, committed to publish polling station results, both in the 2020 election and 2024 elections. As of today, we've not published those results. We have not published results of polling station level in the Fourth Republic. We have countries that we don't consider as democracies who publish polling station results. Because if you do not expose that level of transparency, people will continue to have schemes. We have to get to the point where we can trust. There's all the machinations and things you're finding. It's because people are always mistrusting the process. And the only way you can is to bring sunshine to the process. And we need to get to that point. So for me, it's, as I said, it's not enough. They have to take it forward and find out what exactly happened, who is responsible for what, and hold them accountable. The third point, our jurisprudence is developing around these matters, and it's not only Ghana. This is happening in all of Africa. It remains inconsistent. So the big question about what is a valid election? What is an election that has integrity? For at least maybe a couple of decades, maybe 2 decades now, a lot of the election petitions, particularly in West Africa, has focused on election day and then the outcome of the results. The process issues, and even in the MPP's case in 2013, when it tried to challenge the irregularities, as substantively a problem for the validity of the elections. That was not accepted. You recall the jurisprudence around that. In 2020, we had a similar, it was very procedural. But the question it keeps coming up, how is an election valid if a lot of the processes may be corrupted, right? And what is substantial that could completely invalidate an election? Fortunately for us, the parliamentary petition, PNDC Law 284, and Section 16 and so on is very detailed as to the process. So it's not enough for you to say, oh, we can count the results. If substantially the process to the outcome is corrupted, then you can invalidate the results.
Okay.
So for me, the reason why I'm just spending time on this is that we need to get our jurisprudence around the validity of our elections consistent across both presidential and parliamentary elections. Because if we don't, it will begin to undermine our trust in the democratic process. Then we are very much in trouble.
Something 1 minute or 3 seconds. Could you ask a very important question? I want to put it on. What is a valid election? A valid election is one which is unchallenged. One. Or where challenged, one where a final judicial pronouncement is made on it.
Okay.
We should take this forward.
Last week, around the table here on Newsfile, there was what I discovered to be near unanimity. That one, you say what? Unanimous NF. That is
FC.
Newsfile. Even among the lawyers, that the pending process in the Supreme Court, appears to have a very strong chance of success on the basis of the date of Gazette. And the date of Gazette looked at against the date of filing the case in court. Now, do you share the view that when all these matters were pending, Parliament should have been slow, and what the Supreme Court has done now is the best way to keep sanity, to maintain sanity?
So you have boxed a lot of questions into one. A lot. And let me say that I agree entirely with the submissions of Dr. Kojo Asante when he says that it is not common sense, but it's the presence of gaps in the law that has caused this problem. I hear many people talk about patience, patience, patience. How do we define that patience? And when do we invoke patience as a remedy to a lacuna? And how long can we be patient? So you need to identify the gaps in the law and deal with the gaps, rather than throwing it out in the air. Because the idiosyncrasies does not actually represent the law. Okay? We want things done a certain way. But is that what the law says? To get everybody to understand that when a matter of this nature arises, this is the procedure. It's the reason why we have regulations or the CI.
Judicial pronouncement.
You understand? Or a judicial pronouncement. Because all of us have opinions on what should have been done. I agree. And you know, on your platform, I said it. Sometimes they say that we are too legalistic on this platform.
The law is everything.
But that's the law. When they were hoofing and puffing in Parliament and drumming tables and throwing papers across the aisle, I said that was not the solution to the problem. I said it on your network. I said the solution to the problem was that Article 1125 had been invoked. And when you read Article 1125, Doctor, it suggests a chain reaction.
A trigger.
A trigger.
Trigger points, yeah.
And so, if
once the clerk has issued within 7 days,
that one,
the EC is compelled.
So what do you do as a lawyer? The options that you have is to arrest the process.
Yeah, that's all.
That's all. So it was not to drum tables.
You said this. You said the solution is a judicial solution.
It's not a political solution. Now tell me, how do you get a constitutional provision reversed by writing a letter to withdraw an act? How do you get it? When that person has triggered a power under the Constitution.
Or holding a press conference.
Holding a press conference.
Or holding Parliament to ransom. That they shouldn't.
You understand? But politics has taken over. And I agree entirely with you.
But of saying their plea, was it a plea? It was a demand. Was that the Speaker should cause a withdrawal of the notice that has been sent to the EC.
But
so if the Speaker had acceded to their call, they would have achieved something.
Well, but does the Speaker have that power in the Constitution? That regiment?
And the Speaker should be minded
and even
about what's going on.
They should be minded by their standing order. So if there is room within the standing order to change the way in which the trigger happens, then it creates scope. But it has to be by law, because that certainty of law is...
By which law? Whoever originates a process has the power to withdraw him.
Well, that process is backed by law. He didn't trigger the process by his own personal wishes.
It's a mandate.
It's a mandate given to him. He has to do it.
Okay.
Do you understand? So let's come to the...
And the court stopped Parliament.
To do what?
From declaring...
The court
at least what they have, yes. They have.
The court has done that.
Oh, wait, so you see, at the time when the matter was filed in court... Yes, I know there was no stay or whatever it is.
Yes.
Did the Speaker have room to be mindful of what was going on in court and hold his hands?
That's an opinion.
I'm asking you.
No, that's an opinion.
Because you see, that's what I'm saying. In the processes of state,
our idiosyncrasies does not constitute the law. Read the Constitution carefully. The Speaker's ruling on the 7 days is even captured in the Constitution.
No, you are not going where I'm going. See, not everything is written in
talking
law.
about the exercise of discretion.
Yes.
In a way that demonstrates wisdom and appreciates our security situations. Because as we understand, Kpandai is a security situation.
So you see, that's the problem. All of us know as lawyers that where discretion is not regulated by law, it's subject to abuse.
But that's why, Inusa, you are a very seasoned, you are a seasoned lawmaker. Inusa, we are in the realm of opinion. And we should do this. Your words will have a lot of weight. In this situation, would it have been proper for the Speaker to say, I am constrained by these things and therefore nothing will go amiss if I hold my hand in deference to the courts?
I'm not saying that the Speaker could not have said that. If the Speaker had said that before the letter, that would have been okay.
So please, let me stay on this. See, I have said, and I repeat, Speaker Babin is my favorite speaker of the whole Fourth Republic. Why? He takes decisions. He makes moves. He goes into spaces which are controversial. You see what he wore for his own swearing? He breaks the mold. So for me, that's what makes him my favorite speaker. This is one of those gray areas you are not sure, where he should have made one of those iconoclastic decisions and said that, look, we have, hold on, let me finish. We have 3 arms of government.
Yes.
The Supreme Court, Parliament, and the Executive, and they all have their powers, but they have their limits. And in all of these things, when there's a constitutional issue, it is the Supreme Court I defer to. I will make law. But when there is a matter before the Supreme Court, I will defer to them, just like I would like them to defer to me in other places. It is not written in any law. But this is how you form these kinds of agreements.
If he had done the Speaker's intervention, when prematurely Yindam was being pushed out of the House, was in full compliance with our law.
Correct.
He said,
but he was guided by law.
Automatic stay.
Yes.
After that, processes, if appeals and processes have been filed, they have the potential
of success,
of stultifying the process.
Yes.
So what he did was in full compliance.
Correct, but that one he was guided by law.
Go beyond the law.
He was guided by law. I'm talking about where there is no clear law. Where there is no clear law.
There's clear law here.
About if something is before the Supreme Court.
Except that the lethargy of the courts delay the process. So let's get the things clear. There's clear law here. Let me answer your question before I come to the clear law. So the certiorari application in Parliament stands on 2 things.
Certiorari application in the Supreme Court
stands on 2 things. A supposed Gazette notification that was issued on the 24th and another alleged Gazette notification that was issued on the 6th. Now, so you see, that right of the petitioner to go to court to challenge an election results or the validity of an election rests squarely on Gazette notification. It is what triggers.
Which was the matter?
It is what triggers the rights. And we know in law, where statutes confers a right on a person and provides the procedure, you not only have the right to take advantage of the provision, but you are also compelled to follow the procedure. That is actually what the rule of law is about.
Yes, no problem.
Okay? Now, so why is 24th December relevant? 24th December is relevant in this particular matter because if the Supreme Court says that 24 is the date of the Gazette notification, then the action of the petitioner in the Tamil court is statute barred. The case, and you know the decisions of the courts, the case will not be concerned with the merits, whether the elections were legitimate or not.
So statute barred, let's explain to our audience. It will mean that the time that the NDC candidate, aggrieved, approached the High Court, it was late and there was no rescue. So his case will be voided.
Yeah.
That he couldn't have gone to court.
Not at all.
But
And
if
so,
he computes the date of the Gazette from the 7th,
from the 7th of
6th, right?
Of January.
January,
Yes.
then he will be within time. Right.
Thank you so very much. So you see where the decision of the certiorari application will stand. It will stand on whether or not the January Gazette notification is the proper notification. Does it dispel, revoke, or, replace the 24th December notification? Because both of them will have consequences.
The law's requirement is that in an election petition, like in this matter, you have 21 days. There is no extension for you. 21 days. We didn't wait to bring your grievance to the court. If you allow a day to pass, you are gone. Okay.
So let's go. Who made that mistake?
Yeah.
The Gazette mistake.
You were actually on the floor, sorry.
So the High Court, I've said that this matter could have been resolved. You see, when the decision was given in the High Court, I listened to the parties carefully, the lawyers. And all lawyers do that. Those who have practiced before, when you are going to court, you don't know where the judgments will go. Sometimes you prepare your notice of appeal and stay for execution. Because with a notice of appeal, you can't file a stay of execution. So you prepare and hold it. When you go and it's in your favor, you shelve it. It's just like an election. When you prepare a concession statement as well as a victory statement, and then when you win, you pull out your victory statement and read. So the parties told us that look, they had when they were going to court, they thought that the election, the judgment would not go in their favor, so they prepared. Immediately upon the pronouncement, they filed a stay of execution.
Notice
of execution and coupled their, and filed a stay of execution. I thought that they ought to have pressed the court to have the time fixed immediately after the 7 days. Immediately after the 7 days.
You can press as you want. If they don't mind you, what do you do?
That is the thing. So if you press as you see again, so you are coming to the political. If you press as you want, and the court is not doing what is proper and just in the circumstances, then you have reasons to complain.
By what you're saying, you belong to the school of thought that unless there is an order, express order, a stay of execution does not stay the hand of the victim.
But then I also concede that if the stay of execution is served on the party has a duty to respect the processes of the court.
Okay.
I also belong to us. I recognize that. So again, the question is, was the stay of execution served?
At least it would have been served on one of the parties, which is an office, very easy to go serve.
Is there, Oh, but electoral commission doesn't do. You see, that's the thing.
It's a party. It's a second defendant.
But it doesn't do anything in the process. Their trigger, their action is almost at the tail end. That's why they don't even appear to court. I mean, the court was not happy.
Yeah.
They didn't come.
Which I thought was not proper.
they see themselves as being the.
No, but these matters are very
serious.
Okay,
you understand?
So this is not the first time.
I agree. The court
No. We should speak to it. See, me, where I haven't gone is this. I said, who caused all this trouble? We are.
The electoral commission.
It is the EC. And look, it is important that we keep referring to the
It's fair
EC.
to say it is the EC.
It is the EC.
The elections were going on smoothly.
It is the EC.
Then they are going to do a coalition, and party people start. These people, their security is not even secure.
If they had published police station results the way we have
and
asked,
then we say blame EC.
No, I'm not even on that.
Every
level.
step of
I'm
the
not
way.
on that level.
Yes, on their arithmetical, mathematical error.
Why?
Fine,
No,
but
you see,
the conduct of the polls, the conduct of the polls,
But
the
all of
collection
us-
of the results,
all of us saw
arithmetic error.
all of us saw how party people. All of us saw how party people made collation almost impossible in some of these
The EC, with all that they have, cannot tell us that they didn't have the wherewithal to manage that.
Particularly the NDC. Where the NDC not matching their army to
Didn't they have the
collation center.
the state law enforcement, including the army, to deal with that?
Who has the primary responsibility of
primary responsibility?
the integrity of the election?
If they can't do it, they should
No,
tell
but
us.
on the security, that one you can't put it on the.
No, why not?
Why not? Of the election.
That's why that one. I agree with.
Makujo, why not? Why not?
Not
They can have 100 army people
but you
there.
have
Okay,
a national-
we have one more person who has
This
not
keeps repeating,
spoken.
and then we didn't come to
Let's
court.
go to.
As for that one, I don't.
Let's hear Afetua Ebua. Afetua Ebua, thank you very much.
This all goes
I
back
wanted
to
you
the
briefly. So, what the
How are we
Supreme
going
Court
to
has
resolve
done
30 years of doing
is something you are excited about, or you
Oh,
are not?
I had said that was what the Supreme Court would do.
Okay.
In the interest of justice, fairness, and I mean the fact of if you want to hold the balance. I mean, the Supreme Court is mindful not to put itself in a situation where its judgments can be nugatory.
Okay.
Okay, so the Supreme Court adjourns the matter to 13th of January. Electoral Commission says it's conducting elections on 30th of December. The judgment clearly, if the Supreme Court did not stop it, would have been nugatory.
What happened in the Belabo case?
Okay.
They did that. There was no
Mr. Ebua.
All right, thank you very much. And let me also extend my greetings to my co-panelists. I've followed the discussions. And let me first indicate that there are no gaps relative to how judgments are to be executed, whether constitutional judgments, whether private judgments, etc., etc. And I'm surprised that they have to take the Supreme Court to halt the process. If as a people, we are all committed to follow the laws that we have passed, I think this matter is as easy as ABC, and I insist, as easy as ABC.
Explain to us.
The High Court in Tamale delivered a judgment. Per CI 19, there is a 7-day automatic stay. So from the time of the judgment, for the first 7 days, which Speaker Babin said, nobody could take any step to execute the judgment. The registrar at the High Court in Tamale didn't have the authority by then to serve any process seeking to execute the judgment. That's the first point. Now, after the 7 days, that's where the issues come up. Is there a stay or no stay? After the 7 days, there was a motion for stay of execution. And what's the effect of that application? The effect of it is governed by CI 19, Rule 27, as amended. Now, if we take CI 19, Rule 27(2), it says expressly that when such applications are pending, execution of the judgment is stayed. Rule 27(2) of CI 19. this has also been given a judicial blessing by the Supreme Court in the ex parte Millicom Ghana case. I think it was reported in 2009-2010, Supreme Court of Ghana Law Report. Now, in that case, the Supreme Court said, the moment an application for stay of execution is filed, it stays execution under Rule 27(2). And so, I'm going back to Tamale. The lawlessness, the illegalities, I will trace it down to the registrar at the High Court in Tamale. At the time that, presumably, I presume that he served the Speaker of Parliament or the Clerk of Parliament that there was a vacancy. At the time that that warrant was served, there was pending on that particular docket a motion for stay of execution. Question: so on what basis was the clerk notified that there was a vacancy? That's the first point. Now, if you come to Parliament, I also listened to the arguments on the floor, the majority leader and the rest. I think some members of Parliament, especially my learned colleague, the majority leader, misread CI 132. But there's an argument that CI 132 has amended CI 19, and by virtue of that, if you file an application for stay, it does not stay. If you take CI 132, it does two things to Rule 27 of CI 19. It amends Sub-Rule 1 and Sub-Rule 3. Sub-Rule 2 was not amended. And Sub-Rule 2 is a provision that deals with the situation where when application is pending, application for stay is pending, it stays execution of that judgment. So as simple as that. And so the moment the registrar, the court below, served the Speaker of Parliament, and also having been notified, Parliament having been notified there was a pending stay of execution, the Clerk of Parliament, with all due respect, also had no authority to have notified EC about the vacancy. That's why I say it's as simple as ABC. Again, EC, as you all agree, is also a party in this particular matter, and in fact, the court below was the second respondent. And they were also served with every process, the stay of execution. When they also got that process, they should have also indicated to the Clerk of Parliament that we've been served with this. But there is a pending application for stay of execution that also stays execution. Let's remember that what was done at the Tamale High Court relative to the service of the warrant or order on the Speaker can also be brought up at the Supreme Court for it to be quashed on grounds of illegality and nullity. And so if EC didn't do it, and the issue was raised on the floor of Parliament, I expected that the Honorable Speaker of Parliament will have delivered a second ruling on the matter, because the time that he delivered the first ruling, he relied on the law, specifically the 7 days automatic stay. The second argument that came at the time, there was a pending stay of execution. And if the Speaker had taken a look at that application and then the law, it would have given the ruling to the effect that the Clerk of Parliament erred by forwarding that notification to the EC.
I've heard you give the education around this subject, but there are those who say what you are saying does not help because of what is said to be the mischief rule. People will do mischief by simply filing applications to stay processes when they know that they don't have a case, and then that will stop the functioning of the affairs of state. What do you say?
There is no mischief here, with all due respect. There is no mischief. Now I'm going to cite two instances. If there is a judgment between Samson and then myself, with respect of a house, you win the case at the High Court, I'm in possession of the house, you want to demolish that house, I go to court to file an appeal and stay of execution. And that house is demolished despite the pendency of that application. Even if we didn't have Rule 27.2, commonsensically, what happens to the application pending? If you go to the court, because that particular court has been used to execute the judgment, despite the pendency of that application. So, in terms of common sense, that application will have to operate as a stay of execution. Now, let me come to your point. Constitutional matters, statutory matters. We are now talking about judgments. The Tamale one is a judgment. It's not an interlocutory application or process. Now, when it comes to final judgments, there's no distinction between constitutional, statutory, or private judgments. They are all judgments. And their execution is done in accordance with CI 19. And so, whether constitutional or non-constitutional, it is a judgment.
Okay.
Usually, we want to look at it this way. There may be a mischief because the person will file an application, that application will stay execution. That is fair. Parliament has passed that CI. If we want to look at instances where there are some situations that we think that stay should not operate as automatic stay, Parliament can look at the law again and say, when it comes to A, B, C, we are not going to countenance application for stay as stay of execution.
So you have been making the distinction between stay of execution and injunction, and your view is that people are reading the injunction processes into stay of execution because the injunction would normally have come when there is no judgment, but the stay would have come when there is a judgment. And you say that makes a difference. Is that your point?
Exactly, Samson. I've also heard the argument that by virtue of the Supreme Court decision in Ekwasefwa, the total removal case, by virtue of that decision, it means that if you also file stay of execution, it should not stay. Now, if you look at the Ekwasefwa case relative to that subject, it is about injunctions. Injunctions pending proceedings, interlocutory injunctions, not injunctions granted after judgment. The Supreme Court realized that as practitioners, for a very long time, there is ex parte Moffat, and then IET and the rest, which have given the decision to the effect that when a motion for injunction is pending, you cannot go ahead to do the very thing that you are basically to stop you from doing. That has been the position of lawyers. That is, we use that word to cite contempt of parties. You can realize that no, when it comes to injunction, when it comes to constitutional functions or statutory functions, that aspect of ex parte Moffat should not work. And that's why, in a very clever way, which I endorse, the Supreme Court said, when it comes to constitutional functions, the filing of application for injunctions does not operate as injunctions unless an express order is decreed.
Okay.
Simple as that. That pronouncement of the Supreme Court does not extend to stay of execution.
Okay, thank you. Dr. Pumpuni Asante has a question for you, but all of us lawyers, we have often said ex parte Moffat, and even when we make the corrections, we still don't come to the fact that it is not ex parte Moffat, it's Republic versus Moffat, ex parte Alote. Okay, yes.
Yeah, but just a quick question. So, I mean, it comes back to this issue about gaps, right? And I mean, you dismiss that as you don't think there are any gaps, but given all the education that you have given us and the nuances that you have, tried to elaborate, I mean, don't you think, or would you consider that Parliament, for example, review its standing orders to provide guidance, for example, on the way it treats judgments of courts, right? So that it offers some structure and some clarity. I worry also that because we are basically dealing with almost like a common law, sometimes it's also by legislation. But if these nuances are changing all the time, how do you ensure that the agencies, as Kofi is saying, who have to apply these things are properly, advised?
Respectfully, is it the politicians who are bastardizing the law which is settled, or that there actually are gaps? From the explanation he gives, there is no lack of clarity on the law. There doesn't appear to be any gaps, but it is the politicians who continue to bastardize it.
So it comes back to the speaker.
As we speak now, you can see how the NPP are celebrating this suspension. But just how many days before that, the Tamale High Court decision, look at how the people's commentary, they take that judge's decision to bastardize the entire judiciary.
No, so
the same way the NDC was doing with unanimous FC.
Something is right. You are also right. But that is why I keep saying it now falls to the speaker. Let us ask the speaker where they will fight.
Kofi, the issue for me is, you see, in all of these processes, there are administrative things that you have to follow, right? There's a trigger, and then you have to act in a certain way. You can interpret the law, and he's made, where the distinctions are and all of that stuff. Now, the administrative procedure that allows us to kind of manage the political incentives that are around it. It's for me that where you need clarity, because another level of clarity, rather than leaving it to say just a speaker's ruling, which is mostly discretionary, really can create problem.
Doc, the point I'm trying to convey to you is this. On the floor of Parliament, you had lawyers of many years of experience.
Who are politicians?
More than decades.
Who are politicians?
Who are sitting in the House. A judgment is given today. They say, let's mount roadblocks. The MP cannot enter the House. Those lawyers ought to know that the basic law is that there must be an allowance for 7 days before you can execute the judgment. Do you blame that on gaps of the law?
Because, you see, I will give you another example. All the issues...
For that one, there's no gap.
No.
There are areas where there are gaps. What to do...
I agree. I'm just saying...
In the same way,
there's no gap.
In the same way,
I don't want to...
Yes.
There are gaps.
Yeah,
why?
There are gaps.
Why? You read Article 112.
Yes.
It talks about when the vacancy occurs.
Correct.
Whenever a vacancy occurs.
Right.
The vacancy occurs under Article 97.1. Okay?
The High Court pronouncing a vacancy.
Please, a vacancy occurs. I mean, when a person dies, a vacancy occurs.
That's right.
You don't need a High Court.
That's right.
Okay? When the person has been dismissed or sacked from Parliament by reason of contempt, you don't need a High Court. A vacancy has occurred. So when we say when a vacancy occurs, we are narrowing it down to the High Court. At which point do we say a vacancy has occurred? That's my understanding. At which point? Then the former Deputy Attorney General says, no, a vacancy has not occurred because when you look at the Court of Appeal rules, CI 19, Rule 3 says that, look, a vacancy, when there's a pending appeal, then the decision, the decision of the courts has to be stayed automatically.
Right.
Okay? And we, as lawyers, know that it's because of the potential effect on the decision of the appeal. That's why the court is there in the CI 19 rules. For me, Parliament should be guided by regulation, and I think that is very important.
Yeah.
It should be guided by regulation that, let me tell you how an abuse can occur. You know, remember the Amartin case? How many months did it take us? Can you remember?
It took a long time.
A very long time. That was an exercise of discretion.
How about Joseph?
Yeah.
What about Joseph?
Yeah. But you see,
once again, if I may ask him, if I may ask him,
so you see,
if I may ask him, why are we blaming the law and fixing gaps in the law when it is so plain on its face?
No.
You spoke about when a vacancy occurs, and the Constitution, as you referred to, Article 92 therefore, clearly says vacancy. He's dead. He's gone.
He's gone.
He's not come to Parliament for how many continuous days without permission. He's gone through a disciplinary process. He's been removed. The vacancy has occurred. The High Court has been given an opportunity to pronounce that there's vacancy. A vacancy has occurred. Why should we still need a clarity?
In the case of the High Court, because of the pendency of an appeal.
Yeah, because it is something. Even in the last, I think in the end of 2024, just before the election, when certain vacancies were declared, for instance.
By the Speaker.
Yes, just remember that you are also dealing with competing rights, right? The rights to be represented. And so at that point, the rights to be represented were vitiated because you can't go and organize an election because you couldn't organize an election in 90 days to the so if you create that kinds of scenario where people are agitated because you are basically left them with no remedy, We have even the issues that the courts had, the Speaker had with the Supreme Court. Now you're talking that to say the Speaker is
my favorite Speaker.
But at that time,
clarity to these things.
At that time, when it was him that the Supreme Court was going after, he basically suspended Parliament for how long? As a way of going around.
That shows you how much power he has to go around things.
So what I'm saying is that we are constantly getting, and you are right that you put the issue around the vacancy. This is where the trigger, the political trigger is coming from. The fact that either you take somebody out of Parliament or... So people are, as you were saying, trying to find ways to circumvent what they know.
No.
That is a governance problem that has to be addressed. It's not going to be addressed by the current arrangements that you have. It's not sufficient. That's what I'm saying. Either we have to look at the standing orders or look at other processes to see how we can deal with this vacancy occurrence and how to address it.
Okay, thank you.
Sorry, I asked him a question and then I ended up answering.
Okay, quickly, because we need to move on. Yeah.
The answer is very simple. There are no gaps. The law is clear. Parliament should rather get legal counsel.
Yeah, they have. All lawyers. They have. They have. There's a legal department of Parliament.
When it comes to vacancy, and the vacancies arising out of a judgment of a court. If the Speaker hears it on radio, the clerk hears it on radio, there's no vacancy. There's vacancy only when the Speaker has been served with the order by the registrar of the court below. Absent service, there is no vacancy. And that's why the 7 days he doesn't have to serve. If there's a state of execution, he doesn't have to serve until that matter is disposed of. Thank you very much.
Interesting. Yes, thank you.
That is trite law. I mean, if you hear...
So why are they not using it?
The Speaker's jurisdiction is not invoked by radio announcement.
Yes. So why are they not using it?
Or is it invoked
I was asking a final question before I move on to take a break and return to Oforiatta and Boku. But it looks like you're the wrong person to ask that question.
Yeah, why?
But because even though you are NDC...
Yes.
You are able to take the middle ground.
Yes.
You are able to look at a law and say this is what it is and not define the law on the basis of the color of a party.
You don't do that.
Yes.
You don't do that.
So that's why I say that it looks like you're the wrong person to
I'm
ask.
not the wrong person. I'm rather the right person.
So the question was this, that what learning are you taking from this? The Supreme Court.
Yeah.
This was a unanimous decision to suspend the rerun on 30th. Unanimous. The NPP is happy about it. They are very excited.
It's good. It's good that they are excited.
NDC is not exactly enthused.
We are. I mean, that's the whole thing about the rule of law. And we really respect decisions of the courts.
Imagine the court
yes.
had given a different decision.
We respect the decision.
The MPP will not celebrate it.
But every victor celebrates.
Right. But beyond not celebrating it, the kind of commentary that would have been made, the judges would have been picked, they would have singled them out, they would have said, this is NDC, don't you know him? This is that. And then they'll say, this court, they have hijacked it. Because that's the commentary that is beginning. That now the NDC has implanted as Chief Justice. And so, Tamale, it is the reason what has happened. They refer to the judge who referred to George Orwell and said it can only happen under NDC and so on.
Yeah, but so when it happened in Tamale, I told the minority leader, Afenyo Makin, that he was wrong. Tamale High Court is in an election petition. It's a court of first instance. So why do you go after the judge? The only time that you can show tremendous dissatisfaction is when the matter escalates to the Court of Appeal. Because that's final in the case of Nimakain the Court of Appeal is the final. You see, so I thought that even in that case, if the Tamil High Court had not applied itself to the real dictates of the law and given justice in the matter, lawyers, I didn't say politicians, lawyers, and I'm actually addressing Afeni Makan as a lawyer, should know that there is a right of appeal from an election petition to the Court of Appeal. So and that if you don't share in the view of the, and it's an opinion, if you don't share in the opinion of the High Court, you escalate your application. You go upstairs and then maybe you get judgment. Let's all agree that when I was speaking about the right procedure to take, it's not that I was oblivious of political interests. We want as a party and as a government, we want the Kpandai seat. Yes.
You are speaking like a politician.
We want the Kpandai seat.
Right.
But
Okay.
but then,
So let's now move on now. And Doc, your concern about speed.
Yes.
So as we understand, there was supposed to have been a ruling on the stay on the 18th of December.
Yeah.
The judge had adjourned it, to 18th of December, and 18th of December, no show. So there's no ruling.
Yeah.
It appears that there's no urgency attached.
Yeah, but the point that even the applications were made January, and now that we are getting a judgment in November, I mean, we can't.
Right.
It's too disruptive.
That's the point I want to make.
Okay. Okay. So I have this comment. It's a bit lengthy, but it's important to read, and it's about all of these arguments by the politicians on whether or not the stay, once filed and served, is sufficient to stay the hand of the process. This is Frederick Gura Sampson. He writes profusely on legal questions. He says, the law under Article 99 confers a right on an aggrieved person to appeal and challenge the decision of the High Court. As part of the appeal processes, the execution of the High Court judgment can be stayed with the filing of an application for stay of execution. The filing and service of same should stay the hands and prevent the execution of the decision by the Clerk of Parliament notifying the EC for the rerun. Vacancy actually arises after all appeal processes and opportunities to challenge the decision of the High Court has been exhausted. It cannot be said or argued that the mere declaration by the High Court ipso facto implies a vacancy without having regard to, for example, Article 99(2) of the 1992 Constitution and Section 10 of PNDC Law 284, which, though not direct to the point, is instructive and provides guidance. I disagree with the view that the constitutional clock must continue unabated. The process must bow and defer to the judicial processes. The declaration of vacancy is in the bosom of the judiciary, not Parliament. Once processes are pending, by-election or rerun cannot be held.
No.
It's good their lordships at the Apex Court have suspended the rerun to abide the hearing of the certiorari application. That's constitutionally progressive. Any attempt to go ahead while judicial processes are pending is a betrayal of the constitutional fidelity. And on this note,
Francis,
I take a break.
Samson, you haven't come to me.
Samson.
I've come to you many times.
Samson, we need to what he has done is to narrow his right to what has happened.
It's a tall article. This is a portion of it.
But you see, a vacancy is doesn't necessarily arise out of a challenge to an election.
Okay. Yeah.
And you cannot give a blanket statement that the declaration of a vacancy is in the bosom of the court, unless you qualify it in an election petition. But because if a person dies, and we've had a lot of by-elections by reason of death, they're pronounced by the
Yes, Kofi, so quick, we need to take a break.
We need to go back and finish this business of election petition courts. Why can't we pick 20 judges, make them election petition experts. When there's an election petition, they sit on it. You draw them from the normal court. They sit on it till it's done, and the process stops at appeal. We need to do this and avoid all these issues. Because they'll never stop.
Send it right up to
Oh, he's hearing us. And who doesn't agree with us?
that to him.
We've discussed it at length. I'm saying let us do it. We need to do it.
Even
it will
before,
save us a lot.
Look, Benton, you are wrong. When you say elections are not determined at the polling station, they are.
Who? Why do they go to court? If they are determined, then Yinam will be MP. If that is so, then Yinam will be MP.
When the polling station results are collated, first instance is
never ultimate.
Okay.
It's not ultimate. Then secondly, yes, you cannot challenge an election.
Of course, that's
all right.
It must be our laws.
Okay, thank you, gentlemen. We'll go for a break. When we return, Ken Oforiatta, the Attorney General has eventually forwarded the OSP's extradition packets to the Foreign Affairs Ministry, who have also forwarded it to the United States of America to begin the process to extradite him to Ghana to face prosecution. So, will we succeed? The Attorney General suggests he's engaged very top-notch lawyers, and so it doesn't look like we are going to see an extradition happening anytime soon. We'll be right back.